This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. Happy Friday. I am Stuart Address, and this is Ask a Lawyer. I'd like to say hello to my thousands of listeners. Well, maybe that's hundreds.
Oh, it could be
Dozens?
hundreds of thousands.
Maybe it's dozens. I mean, we're still only about
Who's counting?
16 weeks in, so we've got to still develop that audience.
Mm-hmm.
But we do thank you for the calls and encourage you to call with any question you may have. Here's an opportunity to stump a lawyer or get a real answer, and maybe I can help. Anyway, I think we're going to start talking today about client relations. It is the number one reason for bar complaints against lawyers in the state of Florida, and I dare say probably throughout the country. And a lot of that is the lawyer's fault. And some of that is unrealistic expectations by clients.
Mm-hmm.
So I figured we would chat a little bit about what you can expect and what you should expect from a lawyer, and what the lawyer should expect from you. So starting with the more important part to you, what you can expect from a lawyer, the first thing I think you really should be able to expect is that when you're talking to your lawyer or his paralegal or her paralegal, you get to finish your story. They need to know everything you have to say. Now, that doesn't mean you won't get interrupted. I always tell my son, when he's trying to talk to me, sometimes even my girlfriend, and I interject, I am not interrupting. I'm interjecting to ask a question. If I save my questions to the end, like a lot of professors say, I may have 20 of them and I'll forget 10 of them.
Well, isn't that called conversation?
Exactly. Thank you very much.
Yeah.
I think I just blew up the sound thing, Majiggy. Man, oh man, I say that all the time. That is my favorite. That is called conversation.
Yeah.
And so the number one thing you really can expect or should expect from a lawyer is conversation where, especially in that initial consultation, you're going to be able to tell everything you want to tell that you think is important. And the lawyer is going to be able to ask you questions that he thinks is important from the legal side. Where, as you're telling your story, let me tell you what really happens behind the dark screen. You're telling your story. Now, in my office, what happens is my paralegal is taking notes.
Mm-hmm.
I'm not really taking notes except for maybe a couple of things I jot down because I want to focus more on listening than on writing. But as you're listening, or as I'm listening, what is going on as you're talking is I am putting what you're saying into compartments, and I'm trying to interpret them from the perspective of legal causes of action.
Mm-hmm. Well, I would think that the person has a lot of emotional things to tell you.
Very often.
And you're trying to pick out the legal things.
Very often, but you have to let the person get the emotion out too.
Okay.
Otherwise, trust me, they will walk away feeling like they were not heard. But you're right. I am trying to make sure I hear the elements of a cause of action.
Mm-hmm.
And so very often, I will interject and say, well, let me interrupt for a second. Let me ask you this. And I'm doing it because I'm trying to take what you just said and make sure I have heard a particular element of a cause of action. If you've come into my office about discrimination, I'm, in my mind, thinking of the elements that you have to prove if we ever go to trial.
Mm-hmm.
And so I'm listening to that from that perspective. My paralegal's trying to take notes about everything, as if she was a stenographer, which they really don't have anymore. That's like an occupation long gone by. Closest you come now is a court reporter.
Mm-hmm.
But I'm listening, trying to hear the elements of a cause of action, and also then damages. Because there's always two sides to every case. There's the side that is liability do you have a claim? And then if you have a claim, what kind of money can you expect to get from it? Or can you get money at all? For example, we had somebody in earlier in the week who they had the greatest claim for sexual harassment. I mean, I'm sorry, not sexual harassment. I have that on my brain right now. For gender discrimination. But the company closed a week earlier. So no case.
Yeah.
Okay. Or you have somebody that you have a claim against that, is in public housing, and you're never going to collect a judgment from them. Not in a million years. So if you go and
there's nothing to collect.
Right.
Yeah.
If you go and get that judgment, what we like to say is it's good to use for wallpaper on the walls. I mean, it's not worth anything else. And so we're listening for all those things that we can give you the appropriate advice. And then you can take it or leave it. But that's the number one thing, really. You should be able to talk to the lawyer, especially at the initial consultation, and say everything you want to say before you have to leave. That doesn't mean it'll be a monologue, but you should be able to say everything you want to say. Now, what happens if you hire that lawyer? Well, you should, again, be able to say what you need to say at various points along the case. Now, sometimes you can say it, particularly with me, in an email, and sometimes you'll get an email response from me at 2:30 in the morning. But one way or the other, you should be able to communicate with your attorney. And when I say attorney now, I'm including attorney and paralegal, because that's usually the way it works. And whether it's by email or by snail mail, some people don't really use computers, not as many anymore.
Yeah.
Or whether it's by the traditional calling the lawyer's office. You should be able to get in touch with somebody relatively quickly, especially if you're an existing client. Now, quite frankly, the initial contact you're likely to make is with the paralegal. And the paralegal, if you're an existing client, is going to try to help you through whatever the issue is. And if, in this case, if she needs to ask me a question or two, she'll ask me and then she'll go back and tell you. And, not in every conversation when you speak to me, if there's really no need to, you won't. But let me tell you something, because this is one of the biggest complaints I hear when people come to my office and they've had a lawyer and they're thinking about changing a lawyer. If you really feel you need to speak to your attorney, you have a right to speak to your attorney. And it doesn't matter if it's the paralegal or anybody else. There's only so much screening of calls that is appropriate. At some point, if you say, I really need to speak to Stuart about this, then you have a right to expect that either I'm going to get on the phone right then or I'm going to call you back within a reasonable period of time. And I think you have a right to expect that from any lawyer. The stories that I hear of, well, I hired this lawyer, and now we're a year into it, and I've never spoken to the lawyer. All I do is speak to his paralegal. That's a bad sign. Because ultimately, if you're going to go to trial, guess who is going to be your partner in the trial?
Oh, so it's like, oh, hi, glad to meet you,
Exactly.
finally.
And,
That's
look,
not good.
That may be good in an appellate case where you're doing a monologue in front of some judges, but it's not good for a trial where you have to interact together and have a trust in each other. If you don't have a relationship, there's no trust. So, when I have people in my office or they call my office and they say, well, I'm really unhappy with my lawyer. I can't get a hold of my lawyer. They won't let me speak to my lawyer. I know that most likely that client is going to be getting a new lawyer, whether it's me or somebody else, and so I'm more than happy to speak with them if it's in my area of practice. Now, sometimes, honestly, it turns out a little bit different than the initial facts you get on the phone. Sometimes they'll come into my office, and what I will hear is a little bit of impatience, not so much of a delay on the lawyer's part, and I'll give them a little bit of advice. Before you fire your lawyer, before you hire a new one, whether it's me or anybody else, why don't you do this? Send your lawyer a certified letter. It will get his attention. And if you still don't hear from your lawyer or you can't make that relationship patch up again, then fine. Come on back to me or come on back to somebody else, fire your lawyer, and, get a new one because at that point you really should have one. So reciprocally, when you're calling your attorney or you're emailing your attorney, there are some questions that can't be answered immediately. Some of them really require research. And so, the best way, in my opinion, to handle that is to shoot off an email to the client and say, I've gotten your voicemail or I've gotten your email. I need to look into this. And, I'll get back to you, I think, in 1 or 2 days or 2 or 3 days or whatever it takes. But let them know what to expect. Because I'll tell you something. I've been a client, too. I've been a client in a divorce action. And I've been a client in New Jersey in a couple odd cases. The one thing a client doesn't want when they call their attorney's office and they feel there's something important that they need to say, they don't want to feel they're not being heard, they're being ignored. Because to them, this case may be one of the most important things going on in their life. Now, granted, some lawyers have 100 cases, some lawyers have 200 cases, some lawyers have a dozen cases. So it's not, your case isn't the only one they have. Mm-hmm. But to you, your case is the one that's important. And lawyers need to understand that.
It's the kind of thing, too, that you're wanting to put behind you.
It is.
So,
and the only way you can do that is to move the case forward.
But it takes some time.
Yeah. For example, on my way here, at a stoplight, and my vehicle was not in motion, I happened to, my screen, my whatever it is on the car, tells me if I have a text message.
Okay.
So I can press listen. And I had a message from a client asking me if I had her demand letter ready yet. Obviously, she wants to see a draft demand letter, and I don't. I don't have it ready. I honestly have not had an opportunity to even begin it, given what's been going on in my office the last 2 weeks.
Okay.
I immediately dictated a short text message back to her saying, no, I don't. I'm sorry. Things have been a little crazy the last 2 weeks, and you did move from Florida to another state, so it took some time for you to get me the information I needed. I will have your demand letter done by the end of next week. I hope that's satisfactory. Mm-hmm. Now, that's my way of saying mea culpa, and here's when I'm going to have it ready, and I hope that's okay with you. And I have found that with most clients, that's good enough. Mm-hmm. They'll wait a little bit longer.
Well, your quick response to her message was probably what she needed.
Exactly. She's not being ignored.
Right.
And you're right. Now, if there had been no response to that, and on Monday she had to call the office, and she didn't get a call back until next Thursday.
And her story was, I called last week, I left a message, I still haven't heard from anyone.
That's right. And that's where people start to get frustrated.
Right.
Mm-hmm. Look.
In any business.
I'm about to try to get my side yards fenced in. We just had a pool put in.
Yeah.
And our side neighbor has a fence, our rear neighbor has a fence, our other side neighbor has a fence, and they've all been designed to look exactly alike. So I want to get the two sides now closed in, mm-hmm. so that now, the area is protected, mm-hmm. and have it look just like the other fences.
Okay.
It's not a big job. Now, I got 2 quotes relatively quickly mm-hmm. from 2 good fence companies. To me, they seem a little high. Mm-hmm. So I got a recommendation from somebody to call another company. I've called them 3 times. They've never called me back. I'm not calling a 4th time.
No.
They just lost business.
Mm-hmm. There's been a lot of that in the sort of construction-y, they want to do new stuff. They don't want to come to existing homes and do little jobs for people who need little jobs. But we all have these little jobs we need.
But little jobs sometimes lead to bigger projects and more work.
Yeah.
And it's the same in the legal field.
I have to say, it's like nobody needs any money.
Well,
apparently they don't need to work.
They should retire to Mar-a-Lago.
Yeah, they don't need any work.
It's the same in the legal field. If a potential client, we on our office call them PNCs, potential new clients.
Okay.
So if a potential new client calls and, let's say they don't get a hold of Cheryl. Hi, Cheryl. because she's on the line or on two lines or what have you, and it goes to voicemail. We need to call back relatively quickly because, number one, if they're really interested in us and they don't hear from us, they're going to go look for somebody else.
Mm-hmm.
And if they're not really interested in us, but we're just one of the few people they're calling.
They were like looking through the yellow pages?
Yeah. They're going on to the next one.
Yeah.
And, look, you're going to lose a number of cases that way because you couldn't answer the phone right away. That's the way it is. But you don't want to lose $1 million case because you didn't call back. So the moral of that story is that you do have a right to have your attorney, be readily accessible within reason to communicate with you. You have a right to communicate with them. And when that communication breaks down, that is a giant red flag of a problem. And if, you can have lots of different cases with attorneys. Not all are in litigation. Most of mine are litigation. But I would say particularly in litigation, where maybe the case is one day going to go to trial or you're in the middle of discovery, if that relationship breaks down, you're probably in the beginning phases of a divorce on your way to a new attorney. Mm-hmm. Because let me tell you something. If you do have to go to trial, you need to trust your lawyer, and your lawyer needs to have faith in you too. And if you're going to go to a mediation, which we talked a little bit about last week, and your lawyer says, well, this isn't as high as we were hoping, but under this circumstance and that circumstance and this new piece of information I heard, I think you might want to consider accepting it. The only way you're going to listen to that advice is if you trust your lawyer. If you think that lawyer is an SOB or a buffoon or a blowhard or just spouts lots of fancy words, you're not going to take his advice. So, it's a big deal to me because I hear it all the time. I know the statistics at the Florida bar. To me, it's stupid for an attorney to get in trouble with the bar over not communicating with an actual client.
And because this is a professional profession.
Yes. Well, it's supposed to be.
Dealing with the law, you'd think there wouldn't be any problems.
Sometimes what the clients don't know, although usually I tell them, but sometimes what they don't know is that their attorney had a conversation with the other attorney, and it was a yelling and screaming match with somebody hanging up on the other person. It can get pretty nasty sometimes. Now, on the other hand, I just settled a case this week, a very small case. Just settled a case this week. A gentleman who's a vet had gone to a doctor's office with a service dog. Service dog had his little certificate. He had actually been trained. It was a real service dog. Been trained to help the vet with a couple of things just in case things happened. And the dog happened to be a monster dog, a giant dog. Mm. But at the doctor's office, the dog just sat between the guy's legs, laying on the floor, not saying a word, not barking. I guess they're not going to say a word, right? Not barking.
Well, they communicate in their own way.
Right. Not growl. Just very well behaved, like a service dog is supposed to be.
Right.
And the guy's there for 2 hours, which, it's happened to me too. I hate it. If your lawyer keeps you waiting 2 hours, walk out. If your doctor keeps you waiting 2 hours, I guess it's not much choice sometimes.
Yeah.
But finally, the doctor comes out, because somebody must have told her, and says, I cannot see you today, not with that dog here. That is a violation of the Americans with Disabilities Act, which has a title that deals with service animals. And he came back for a second appointment, and it happened again. And somehow, he's down much further south in Florida. Somehow he found his way to me. And, it's not a big dollar case. It just isn't. It's not a case you want to have in a trial. So we decided to see if we could resolve it with a demand letter. And I got a call. This doctor down in wherever it was, Boca Plantation, Boynton, wherever it was. Boy, she must know somebody. I got a call from an attorney at one of the giant law firms in the country out of Philadelphia.
Ooh. Well, you know what they say, Philadelphia lawyer.
What do they say?
I don't know. I think there's you want to hire a Philadelphia lawyer?
It says that you want to hire a New York lawyer. I practiced in New York and Philadelphia when I was in New Jersey. And I find with these big law firms, very often they see a solo practitioner on the other side, and they think, well, you're not very good, and we're going to walk all over
Yeah,
you.
we're really big and you're just a
Right.
guy.
And we're going to threaten you and intimidate you, and you're just going to walk away. And with me, frankly, it doesn't work. I'll just, you fire a bullet at me, I'll drop a nuke on you. And then we'll learn to get along with each other. But anyway, this attorney was not like that. This attorney was very professional, very polite. We disagreed on what happened. We agreed that we were going to disagree on the facts. So now the only question was there a rational, reasonable way to settle the case where the doctor wasn't going to get too bent out of shape and my client was be willing to accept whatever amount we agreed upon? And so we went back and forth a few times. Every conversation was polite and professional, and we came to an agreement. Yesterday, actually. It was quick, it was easy, it was polite. That's the way you hope it is. But sometimes, let me tell you folks out there, your attorneys are yelling and screaming at the other lawyer like you can't imagine. Like if you have 2 little kids, that's what they sound like. And unfortunately, it doesn't really help the case unless it's in the beginning and they're just trying to test each other before they get to a more professional relationship. But if it's 6 months into the case, if you're paying hourly, you don't want it because you're paying for all that. If it's on a contingency fee, well, I guess you don't really care as long as your lawyer's coming out on top. But it is not the best way to work, and it is stressful to the attorney too. So before we take our little news break and find out what's happening in the world, I'll also tell you that one of the things you really should expect is getting copies of documents from your lawyer. And we can talk more about that when we come back from the break.
Actually, we had 2 minutes, not one.
Oh, you lied to me.
No,
I can no longer trust you again. All right. Well, let's talk about copies of documents for a
So
brief
now you have like a minute and 20.
minute 20. I'll stretch it. All right. Some lawyers don't send their clients anything. And very often, again, they get in trouble, and the clients call and they complain, and they don't know what's going on. It doesn't help anybody. My office, my practice is, for the most part, if I'm sending an email to the other attorney, I'm blind copying my client, unless there's a reason not to, yet. Okay? If I'm responding to somebody else, I'm blind copying my client. If I get in a letter from the other attorney, I'm copying my client. My goal is that at the end of the case, if my client wants to, he has a file that looks like mine. If he wants to keep it nice and neat, he has correspondence, he has pleadings, he has discovery. And that way, when I tell him, you need to go back to the interrogatories and look at number 5 because I need a better answer, he knows what to do. Sometimes it's just a big mess in a box and never looked at it.
Yeah.
But we'll talk more when we get back.
You're listening to Ask a Lawyer here on WPSL Digital 1590. Quick break for the Florida State News, and we'll be back with more. Ask a Lawyer continues on WPSL. Phone lines are open 340-1590, 340-1590. Now back to your host, attorney Stuart M. Address.
Hello, everyone. We were chatting a little bit about documents, and I won't belabor the point like lawyers are prone to do.
I think it's great, though, that you right off the bat keep your file. You've got it. You can refer to it when you want.
That's right. And sometimes some clients just take everything and they put it in a box, and okay. Mm-hmm. And I have had a couple clients complain that I'm sending them too many things. And
you keep track of those papers. That's what you're getting paid for.
I explain to them why I do it. And if they tell me not to, I make a note in my file and I stop, except for the important stuff. Mm-hmm. But that's few and far between. But it has happened. There are some clients, when they get stuff from me every day, they get stressed out. Mm-hmm. And there are some types of cases where I can understand that.
Well, I would feel like you're working real hard for me.
sometimes you don't want to think about your case every day. You just want to let the lawyer handle it.
Okay.
So I can understand that. So that's the end of really the documents. You do have a right to know what's going on in your case, and one of the best ways is to see the important documents that are going on as they're happening. You don't have to read them. Sometimes it's enough that you just get them. And so let's then talk now about when it comes time to make decisions in a case. Even if you're not in litigation yet, you're in the demand letter stage. But especially if you're in litigation. You have the right to expect that your lawyer is going to explain to you your options, the pros and the cons of each option, and then you have the right to make the decision. In fact, I will say, you have to make the decision. Lawyers can make decisions on strategy and tactics and things like that they think are best, that aren't affecting your substantive rights. That's what you're hiring a lawyer for. But when it comes to things that truly affect the merits of your case, or whether you settle, or what is the offer, you have to make that decision. And that's actually a part of the rule of ethics. Lawyers cannot, some clients have told me, you have authority to settle my case up to X. I don't want to hear about all the offers back and forth.
Okay.
And I have to tell them, I'm sorry, I can't do that. I understand I have authority up to X, but I'm going to send you an email when I get another offer that's much lower than that, and just let you know, this is what we heard, this is my authority, I'm going to continue to act in that way unless you tell me otherwise. Mm-hmm. And that's fine. But I cannot fail to communicate an offer that is made to my client, even if you tell me not to. I just have to. It's part of the professional rules of conduct for lawyers. So you have to make certain decisions, and I have clients who not only want to give me authority up to X, but one client very recently who owned a business and really didn't want to make any decisions. And his rationale for telling me to make the decision was, that's why I hired you. You're a lawyer. And over and over and over, I'd have to say to him, sometimes in writing, to make sure my posterior was covered. I can make certain types of decisions, but when it comes to these, you have to make the decision. If you have any questions about your options, about the pros and the cons that I've explained to you, I'll talk to you more. If you need to, you can come into the office. We'll chat about it. But you have to make the decision because it's your case, not mine. And for anybody out there, the same comes with settlement. Don't let any lawyer tell you you have to settle. You don't have to settle. The choice to settle and at what number to settle with is yours. Lawyers can tell you, I think you should settle. I strongly advise you to settle. I think you're a lunatic if you don't settle. But when a lawyer starts to pressure you to settle, there's a problem. And look, most lawyers don't do this, but there are, in every profession there are. If it's a contingency case and the lawyer's fee is going to be based upon a percentage of the settlement, if a lawyer is pushing you to settle a case that you don't think should be settled at that point in the case, or it's way too low of a number, get rid of your lawyer. Okay, once the lawyer's interest starts to look like it's more his or her interest.
Or how about the other side?
What about the other side?
Do they make a deal with the other side?
I got to tell you, I think that happens so rarely as to be. I mean, I have clients that ask that question. Honestly, I won't say it never, ever happens because people do a lot of ridiculous and horrific things. But I think it happens truly so rarely as to be not even a blip on the chart. What I think would happen more often is a lawyer sees his percentage right there on the table and
would like to move on.
Would like to take it, and now you're the one standing in the way. And, if the lawyer advises you to settle and the reasons are good and you've already talked about, what you really should be settling for and what the range is, and whether if it's a little bit lower, but there's good reasons why you might want to consider it. For example, I have a client right now. I don't think there is any chance he will survive a deposition. He's too much of a basket case. He will just literally emotionally collapse. So if at the end we get an offer that is a little bit less than I hoped for him, my recommendation to him will be to settle. And I will explain to him, and I've told him I don't think you'll make it through a deposition without having to run to a therapist and, get medication. And that'll be my reasoning to him.
Mm-hmm.
Now, then it's his choice to say yes or no. If he still wants to say no, it's not my business. It's not my percentage to grab off the table. He's the client. And so when you have an attorney that may be trying to push you further than you want to be pushed, that's a big red flag. And at the very least, then you might want to call another lawyer and get a second opinion, just like sometimes you go to doctors for second opinions.
Even at that point, even at the we're negotiating a settlement point.
Right, absolutely.
Okay.
Absolutely. Even if you're just before trial, I mean, it's hard to do, but sometimes that's what needs to be done. I just got hired in a case, don't ask me how because I'm still trying to go through the documents, that has been going on for 7 years. I got into the case.
Well, that's like really being invited to the party late.
Yes. I was definitely second choice. The client just got upset with his attorney for a number of reasons, and ultimately when he was in my office
Wow,
and
there's
told
7
me why,
years of documents.
Yeah.
Wow.
Ultimately I wasn't in a situation where I thought I'm going to tell him, well, why don't you go try to work it out, because it clearly didn't make sense to me.
Well, they're not going to work it out after 7 years.
So, I took the case over.
Okay.
And now I've got to get myself up to speed.
Mm-hmm.
Fortunately, there isn't a trial scheduled, but if there was a trial coming up next month and I decided to take this case, well, I'd basically be putting my practice temporarily on hold to work solely on this.
Yeah.
And sometimes that
You'd
happens.
be cramming like you were cramming for
You're
college.
right, just like it was way back in college or
Yeah.
law school. You better believe it. Now, you also have a right to have your serious problems and serious concerns taken seriously. And we sort of already covered this. If you're at least being heard by your attorney, you may not like the answer. What I would really say to you then is think about it. Do you not like the answer because it's not really what you want? Or do you not like the answer because you really think the answer is wrong and somebody has a bad motive or isn't good enough at what they're doing? Then maybe you seek out another attorney. I think I've mentioned on other shows, every litigator worth his salt has won cases that they really thought they should lose, and have lost cases they really thought they should win.
Mm-hmm.
And I have found on a couple of cases where I have lost a case that shocked the heck out of me when the verdict came back against us. I'm sitting there just as shocked as my client, and I'm waiting to go into the hallway and have my clients very upset. I've been surprised a couple times, and my clients have been less upset than I was.
Mm-hmm.
And that's the way the cookie crumbles. And thank you for everything you did for us. Thank you for listening to us. Thank you for fighting for us. And I'm the one left standing there like I've been left at the altar. They're done. They're on their way home. They were heard by a court and a judge and a jury, and it didn't work out the way they wanted, but their emotional makeup is that's fine. They got their day in court, and they're off to wherever the next thing is. And I'm standing there in the hallway, huh?
How did this happen?
How did this happen? And then you do have those times where the client's yelling at you. And in those situations, you expect it, and you try to talk to them. They're not always at that point ready.
And they'll eventually go home too.
Yes. At that point, they're not always ready to talk rationally. And sometimes you're not ready to talk rationally either because it just happened. Whether you win or you lose, depending upon how long the trip home is, if I've litigated the case in Fort Lauderdale or Miami or Orlando, and I have a while to ride home, it's easier than if I've litigated the case in Fort Pierce. But you debrief yourself on every case, win or lose. what went right, what went wrong. If you're good, how can I change this next time? What are my other options? You're always second guessing yourself, even if you win. And look, that's the way it should be. We've talked about, most good lawyers want to win for their client. Most great lawyers want to win for their client and for themselves because they're fighters. And nobody wants to go into a fight and lose, no matter what it is. So those are most of the things, really, you could expect from your attorney. Now, there are situations, and we're going to run out of time eventually, and we'll continue it next week. What does your attorney have a right to? In a nutshell, really, it's the truth. No matter how bad the truth might be in some parts of your case, the attorney has the right to the truth. And I won't tell you that the truth will set you free, but I will tell you that a lie, in civil litigation at least, will likely result in you losing your case. There have been situations, no matter how many times you ask your client something, sometimes there are things that are not told until the bitter end when they really should have been told because the client really, really didn't think about it, didn't think it was important, it didn't cross their mind, and that's unfortunate no matter how many times you've tried to debrief them, but I understand it happens. Then there are times your client just didn't want to tell you something or twisted some of the facts to make them sound a little bit better, and the truth starts to come out in the middle of a trial, and now you have virtually no time to fix it. If I'm told the truth about something, and it's not case destroying, I can deal with it. Either it's not going to be relevant, or if it's relevant, I can make it less important, or if it's going to do some harm to you at a trial, maybe I try to avoid the trial and we get you a better settlement. Or if we're in trial, maybe in my opening statement, I bring up this damaging thing first so that I'm the one telling the jury in the way I want. It's called controlling the narrative. You hear that on the news all the time now. I'm the one controlling the narrative. And so when they bring it up, the air is already out of the balloon. Doesn't hurt you as much. Juries heard it. But if you don't tell me, and they bring it up for the first time on cross-examination, and you're not sure how to handle it, and you're, I don't know if this is a real word, but you're fumfering all over the place, well, now even the jury's looking at you and figuring they've got you dead to rights, and now they may have to wonder.
And they kind of know, too, that your client didn't tell you.
Right.
And what else were they hiding?
And now sometimes the jury, depending upon how important it is, sometimes the jury has to wonder, do I want to believe this person on anything they've testified to? Or am I just going to not believe them on this? As a lawyer, I don't want to risk it, especially on a contingency case. I don't want to risk the jury not believing you on anything. I'd rather you tell me everything, and I'll be honest with you as to whether it destroys your case, whether it affects your case in a way that we need to try to deal with it without going to trial, or whether we can go to trial and still have a really decent chance, and there are ways to try to help work it out. But that's the biggest thing. It's the truth. We can't do our job if we don't know what we need to know. We also can't do our job if you ignore our advice. Now, again, that doesn't mean you always have to take it, but you have to at least listen to it, understand it. If you don't, ask questions, because ultimately if we get 3 stages down the road and you're saying, well, how come you didn't tell me? But I did tell you, and you just didn't understand, and you didn't ask questions, it may be too late now. So, we can't do our job if you don't listen to us. We can't do our job if we get shocked at a hearing in the middle of a deposition or a trial. We sort of just discussed that. Let me give you a couple of examples without naming names. I don't know. If anybody's listening out there that is as old as I am, you might remember a black and white TV show called Dragnet. And the names are protect, detain, not detain, to protect the innocent, and blah, blah, blah. So I won't give away anything that I shouldn't give away, or that would get me in trouble with the Florida bar. But I once had a client who was having really severe PTSD from what had happened. Didn't want to tell me because she was embarrassed. It finally came time for her deposition. She wasn't doing really well. Now, she wasn't doing horribly, but I could tell she was not doing as well as when I had prepped her. And I didn't know why. And then all of a sudden, in the middle of the deposition, she testifies, I don't know. I don't know how to answer that question. It's as if I'm floating above my body and I'm looking down at myself and I just can't think straight. And I'm sitting there and I just listened to that. And I'm thinking, oh, they're going to read that back to the jury at trial. What, pray tell, are we ever going to do? Now, honestly, that client ended up getting a judgment for $1 million. How we survived that testimony of floating in the air above my body? Well, we dealt with it up front as part of her emotional anguish. And we got her counseling help immediately. So by the time of trial, we were able to show that she'd gone to counseling sessions and this was the diagnosis, and it wasn't just an expert coming in to testify. So she didn't tell me. It could have destroyed everything. We had enough time to make it work out. Another situation, my client is testifying again at a deposition. A lot of these things happen at depositions. And he admits to being a drug addict. Now, look, if you're a drug addict, your credibility is not going to be really high in front of a jury.
Mm-hmm.
But after the deposition, when I took him by the scruff of the neck into the hallway, I said, what the hell? I'm sorry, what the heck?
That's one that you're okay with that one.
What the heck do you mean you're a drug addict? He told me what it was, and it was a prescription medication that he had just taken a little bit too long, felt he'd gotten addicted to, had already told his doctor about it. And I said, that doesn't mean you're a drug addict.
Right.
Why are you testifying under oath that you're a drug addict?
Yeah. You don't have a dealer on speed.
We got to go fix this. All right. Oh, my goodness. I thought he had broken up with me. Bulldog on line 2. Hello, Bulldog.
Hello, Stuart. How are you today?
How are you? Were you like, did they send you to Siberia or something and you had no cell service?
Oh, no, of course I am. Just listening, and if I have something on topic, I call. Otherwise, I don't.
What can I help you with today?
Well, I tell you what, I just want to echo your point, and it's not only valid in the legal realm, but it's also in other businesses' realms as well. And what I dealt with in management and doing things, it's a lot of times people say, oh, yeah, those servers are going to work, no problem. And then they really don't know, and then they tell me the truth later after, and, you know, there's a lot of repercussions for that and everything, but just tell me the truth, because I just went to the CEO and said, we're going to be up and ready. And now you're telling me what we kind of fudged it a little bit here,
right.
And you didn't tell me about that.
And I'm not allowed to say it, but you know it runs downhill.
Yeah.
So, you know, you get in trouble, then he gets in trouble.
I mean,
then,
the case is, and I understand your point, you just be upfront with me at, point zero.
Right.
I'm not assigning blame. I'm not doing anything like that. I'm not handing out punishment, but I got to know the truth.
Well, that's right, and especially in the legal field. Look, if my client comes in and says, I have 12 felonies, okay, in my mind, I may be judging you a little bit. But I'm not really judging you like I'm not going to take your case. Unless...
Well, you don't know what the felonies are,
right.
because you haven't described those. If they're
You've been very busy,
ones,
though,
then
getting
it
felonies
depends
if you
on
have
the
12.
case you're defending against.
That's right. Now,
if you got related felonies, then you got problems.
That's true. And more often, I mean, that's a little bit of an exaggeration. I had a client once that had a whole bunch of misdemeanors. It wasn't felonies, a whole bunch of misdemeanors, and not one brushed with the law for the last 20 years. It was when he was 16, 17, 18. And so he said to me, okay, I was, a real something back then. And I changed my life around and, It's just going to hurt me. And I said, well, no, not really, because there's a doctrine of remoteness, and most likely I'm going to get the judge pretrial to exclude the possibility of the other side bringing them up, because they're more than 10 years old, they're not felonies, and so we can probably deal with that without any problem.
Yeah, and I'd also, as a side measure, look to get some of those expunged based on...
And that's when I send them to a criminal defense attorney, you're right.
Thank you, right. Yeah, I know.
But if he didn't tell me that and it came out in the trial, there wouldn't have been anything I could do to help him. This way, at least I knew. And I could do my pretrial motion.
And it's, I don't know, prima facie, whatever it is, up front with the documents, and that he has these misdemeanors, and we've had this discussion, and these don't come up in court, and you get rid of them.
Well, that is very true.
That's basically all you can do. You gotta kind of, for really non-involvement. They're not involved. They're not for the same offenses that we're looking at today, and all of that fun
and
stuff.
And it's a two-way street. I mean, you've got to be honest with your lawyer or your boss or what have you. Your situation. I understand what you're talking about. And on my side, I've got to be honest with you. I've got to tell you whether what you've just told me is going to be a big problem, a little problem, or no problem at all. And sometimes you're surprised it's not really a problem. So tell me.
Yeah, and your whole point about advising the client on, say, plea agreements or settlements and things like that, you have to be sort of a neutral party and just say, here's your advantage to doing it, here's your disadvantage.
You're absolutely right. And Bulldog, I've been given that sign that I have like 60 seconds before they cut me off and they took that cane and they ring me out. So thank you for calling.
Yeah, right, yeah. I'll take you out and talk to you next week, maybe.
That's a deal.
All right.
Take care.
Thank you, sir.
All right, folks, we have about
a minute.
About a minute. So let me just tell you this. We'll talk a little bit next week about mediation and arbitration. Maybe I'll throw in some war stories. Sometimes they're actually helpful. They're not just fun stories, but they're helpful. They illustrate points. But if you have a question, our office gets calls all the time, my goodness. So if you have a question, you can call the show. Next Friday, 10:05 a.m. And if you need your question answered sooner than that, call my office at 781-8003. And the lovely Cheryl will be happy to answer your call and talk to you before I do. Thanks
of course,
very
because
much.
you're here.
That's right. Thanks very much, folks. Have a great weekend.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.